since the city has been accused repeatedly of not following its own processes and purposely trying to circumvent service, if you would indulge me, I would welcome the opportunity to address that issue.
I believe it's been raised, so you get an opportunity to respond.
I'm sure, as Your Honor and Attorney Charnes realize, service of a subpoena is established. The manner in which you can properly serve someone is established by Rule 45. The department has no authority to dictate that someone use a specific manner of service if service is otherwise done in accordance with Rule 45. And Rule 45 allows service to be obtained on an individual. One way is through personal delivery of the process, either to the person directly by the sheriff, or you can use any person that you want to who's not a party to the suit. A lot of people will use the sheriff's office. Again, the rule allows you to use anybody you want that can personally serve the person who is not a party. The police department does have a sergeant who's here at the courthouse who is a court liaison officer. And one of the things that he will do in a criminal proceeding, because of the volume of subpoenas that get issued to officers, he also will provide a service that is similar, or really exactly the same, except without the fee, that the sheriff's office does. So we allow attorneys to bring subpoenas in criminal cases to the court liaison officer if they would like, just like they can deliver them to the sheriff. The court liaison officer functions exactly the same way, meaning he is not an agent to accept service on behalf of any employee of the police department. He does the same thing that the sheriff's office would do. He goes out and he attempts to locate the employee. And if he can locate the employee, he delivers the subpoena to them, and it is at that point that the subpoena is deemed to be served. He may locate the individual supervisor. That individual supervisor then may serve the subpoena, and it's at that point that it's delivered to the employee that the return of service is filled out and the person is deemed to have been served. I think that some attorneys have been under the mistaken impression that simply delivering a subpoena to the court liaison officer constitutes service on the named individual, and there's absolutely no way that the police department could do that, because we have over 500 employees, and that would require the court liaison officer to keep track of everybody's employment and leave status at any given time. And there's no way to assure that if you left something with the court liaison officer and that person is served, that he would ever be able to get actual notice to the individual in the time required in the subpoena. My understanding is that a subpoena was left with the court liaison officer, and I'm not hearing that any of this until I think Monday of last week, that late Friday or Friday afternoon a subpoena was left for the chief with the court liaison officer. But as I said, the court liaison officer does not have 500 people at his disposal. He finds them when they come back to work. When he leaves the courthouse, he goes to the different districts, he comes up to headquarters, and he looks for the people that he can find. But he can't always find everybody the moment that everyone wants them served. So if you deliver your subpoena at the last minute, the less time he has before the time for compliance, the harder it is sometimes for him to locate the person. The chief was not even in town, he was out of the country, and his first day back to work was Monday. So he knew nothing about this. I knew nothing about this. There was no way that he could have been served. And like I said, we want individual service for that reason, because we have so many employees that we need to make sure that that employee knows what their obligations are and when they're due, and we simply cannot just rely on one or two individuals to accept service on their behalf, and we can't guarantee that we could lay our hands on any particular employee at the drop of a hat. They have leave, they go home, we can't always find them. So that's what happened, is my understanding that is what happened with that subpoena. It was nothing unusual. It was absolutely the normal course of business for the police department.
Thank you. And then your response.
So the subpoena that was delivered to Chief Smith yesterday requested the production of 2 different types of documents. The first were all warning tickets during a particular time period that had been issued by Officer Kelly Stewart. My objection does not address that because we don't object to the production of those documents. Those documents are actually a public record, so a subpoena really wasn't even necessary to request those documents. However,
that's the warning tickets?
The warning tickets, yes. However, we don't have the warning tickets. The reason is because I checked with the records division and they confirmed that the police department does not maintain copies of warning citations. So if a copy is made of a warning citation, it's forwarded on to DMV and the police department doesn't keep copies. So we have no records responsive to that portion of the subpoena. If we did, we would have no objection to producing them. I actually brought an affidavit from the manager of the records division indicating that we don't have any records responsive to that portion because we don't maintain copies of warning tickets.
Thank you. And that leaves the request for all training materials for Officer Kelly Stewart.
North Carolina General Statute 160A, 168, which I also have a copy of if you would like. That statute defines an employee's personnel file as any information in any form gathered by the city with respect to that employee. It lists some various examples, but points out that those are illustrations. Officer Stewart's training records are absolutely the department, what your specialized assignments are, things that we mandate that you go to. There's testing many times on it. We evaluate you on it. You are subject to discipline if you do not satisfactorily complete it within the time that you are given. So we absolutely do contend that it is a personnel record. And as a personnel record, it is not subject to production pursuant to a subpoena in accordance with 160A, 168. It has to be provided upon an order of the court. And with that said, the city would ask that Your Honor not issue an order providing the defense with all training materials of Officer Stewart. First, I would point out that this request is extremely broad, and as such, it is unreasonable and unduly burdensome for the city to comply with. All training materials could include logs where he signed in, tests, instructor outlines, student outlines, just a massive amount of material. And just to give you some idea of the amount of material that could constitute, every sworn law enforcement officer that comes through our academy, which Officer Stewart did, as I recall, has to go through basic law enforcement training. That alone is 5 months of training. It's at least 40 separate blocks of instruction, all with individual tests, outlines, all that sort of material. There is, after basic law enforcement training, there's a year of field training. From that point on, there's annual training that varies and is mandated by the state. There's various training mandated by the city. There's various training mandated by the department. Then there's, like I said, each individual officer may do training unique to that officer, depending on what his assignment is, career development, performance, anything. Interest could cause one officer to go to additional training that another officer may not go to. So to produce all of that material for an officer who's been with the department for 8 years would be thousands of documents. We have a very small training staff. Part of the training staff is at training right now. They're not even at the department. We've got an academy that just started that other training staff is attending to. We've got an academy that just finished that other training staff has attended to. So it's not a matter of putting together a file this big and just producing it. It is a massive amount of material that has to be gone through, compiled, reproduced. In addition to that, I would say that I, at least here, have not heard anything from the defense that would warrant production of a personnel file. He has alleged that he's entitled to it under the Sixth Amendment and Brady, but Brady requires that you do something other than just make a mere speculation that the material is favorable and material to the defense. In other words, you have been able to demonstrate that the material would affect the verdict, somehow reduce their punishment, or affect whether they are found guilty or not. You can't just merely speculate that that would happen. And that's all I've heard, is just mere speculation that these documents contain this material. If there was Brady material in these documents, the department is well aware of the fact that they would have an obligation to at least notify the state. The state would have an obligation at that point to determine whether there's Brady material that needs to be turned over. None of that has happened in this case. The defense has had ample opportunity throughout the entire pre-trial proceedings to request this information, or at least a portion of this information, through discovery. We actually did get a request. We had a hearing here before Your Honor where a very specific type of training material was requested. That was the training material that relates to traffic stop reporting, and the city provided that. But to just make a very broad statement that any and all training material constitutes Brady material, or could constitute Brady material, and we have a Sixth Amendment right to it, I don't think warrants release of somebody's personnel records, even if they're kept under seal. And because they are personnel records, if there is any concern that these documents are going to, be destroyed or anything like that, the city is mandated to keep its personnel records in accordance with the municipal records retention schedule, which requires us to keep them for 30 years. So the training records are not going anywhere, regardless of whether they're placed under seal or not.
Thank you. Mr. Sean.
Yes, Your Honor. One of the cases coming after Brady versus Maryland, which I quoted, Files v. Whitley, and talks about the affirmative duty of the prosecutor to know what's in their files. And I've argued in the past that the prosecutor's office in Durham doesn't know what's in the Durham police officer's files. And one example would be the issue with workers' comp here. Brady materials, prosecutor says it's not in my file. Well, that's not the standard. The standard is there exculpatory information as to trial or mitigation at sentencing that is in the possession of the police department or another authority of the state that is relevant to this particular criminal prosecution. This trial has been largely about the fact that Officer Stewart does not follow the rules and regulations of his department. And we can talk about stops, the calling in to Durham Emergency Communications, and there's training on that.
That's what kind of what I'm focusing on.
Yes, Your Honor.
To ask broadly for training material, or I believe, I'm going to quote the exact language, all training materials for Officer Kelly Stewart, versus the ones that you are talking about. There were some specific ones about, particularly, I believe the evidence in this case was about not calling stop in when you make a stop, and the one about not chasing, engaging in a chase with on a traffic matter. I'm not
Yes, Your Honor.
stating now, but I don't remember any others.
Use of force, the SBI 122 training, we did have a pretrial hearing.
We didn't have a pre-trial on that one.
But there's prior training that he's received in all those areas that may be hundreds of pages long. That's all Brady material. They're required to know what's in there, and they don't. And so,
why didn't the subpoena ask for that? You follow what I'm saying?
Yes,
Why
sir.
didn't it say any training materials that deal with him not filling out? I always get the number wrong. Is it
SBI 122.
122? Any training materials on being able to calling in stops when you make a traffic stop, training materials on not engaging in a chase, engaging a case off of a traffic stop, and you said one more. Right?
Use of force, the use of force, there's a general order on use of force, and there's also training on that. That's voluminous. That would include videos. But that is all Brady material they should have provided. And so there's also training on, do you leave a car on during a traffic stop? Now, under which general order is that? I don't know. So what I'm asking, they didn't meet their burden, they didn't meet their responsibility under Kyles v. Whitley and Brady v. Maryland to know what's in these files. They didn't get us the workers' comp files. These other records that are under seal, they didn't know what was in there. They said, we don't know what's in there, we never do. They don't have a system set up between the prosecutor's office here and the police department to know what's in there, and that's an affirmative duty, as Kyles v. Whitley says. They're required by the Constitution to know what's in there, and they don't. So I'm left to try to get what I can with a subpoena, and forgetting about what I have to do to get to this point to even serve someone. But yeah, sure, certainly, I'd rather them meet their constitutional obligation and disclose things to me so I don't have to do this. But what I find is if I don't cast the net so I can determine did they give me anything, to trust but verify, quoting President Reagan, I'm not going to get everything because I've litigated with them for 32 years and that's what I find.
Tell me this concept about if you provide training to an individual that is Brady material. That is material.
Yes, sir.
But it's not that to providing the material, it's the issues about whether that person, what that person does with the material, I guess, something that the individual some individuality to it, I guess. It's that, yes, all right, we show that we provided this training in BLET that this is the force to be used. And is that, could someone just reading that say, well, that's clearly Brady material?
If I read it, I clearly know it's Brady material.
Because
I've done this for 32
no,
years.
but because, not because you did,
Yes.
but because what reason would it be Brady material? It's almost benign. I present it to you, this is the material, and that's sort of it. How does that convert to exculpatory, just that these materials somehow become exculpatory? I'm not saying that in questioning the individual, or weren't you trained about this, and it's the individual's inquiry about you were trained this and you didn't do it off the books, I believe is the way you termed it there. As compared to just the materials. How would somebody, every training manual ever is Brady material? Just in and of itself because an officer has that, or I'm having, it's not that I can say I'm disagreeing, I'm just having a hard time just this thing about it's a constitutional requirement that everybody would recognize this as Brady material. I'm having a hard time understanding if you just looked at training materials generally in and of themselves. How does one think it's just not training materials versus something that in and of itself is Brady material?
Yes, sir.
That's what I'm having. So I need you to.
Okay.
Kind
I'm happy to. I just don't want to interrupt. My wife's
No,
going to
no.
interrupt. So
well, I talked to your wife about you.
Okay.
No, I didn't. That's what I'm having some conceptual issue with that.
Yes, sir.
Go ahead.
In some of the prior motions that I made for similar types of records, it was always Brady, Powles v. Whitley, the constitutional responsibility of the prosecutor, as well as the Sixth Amendment responsibility of the defense lawyer to be able to cross-examine, to present a defense, to receive materials for impeachment, for presenting affirmative a theory. So both of those, this subpoena is for both of those purposes. It's to impeach the witness when Mr. McMaster, Corporal McMaster, gets up there and testifies, the officer testifies. In this case, Corporal McMaster, I'm kind of hazy what happened on Monday. It seems a long time ago. But in any event, the purpose of, to get these records, if there's thousands of pages of records or hundreds of pages of records about, you have to call Durham emergency communication when you make a stop, that's incredible impeachment material. If I can plot down just like those SBI forms, that thick, doing the same thing. This officer has been trained for 8 years to do this the right way, and he still does it the wrong way.
But let me pause you right there. He said he did it the wrong way. He said himself he did it the wrong way.
Yes.
What if you presented it to him and said, here's, you did it the wrong way? His answer would be still the same. Yes, I did it the wrong way. What does that move the can down the road?
If someone has been trained for 8 years, starting when you're in Reali-Tea, the basic law enforcement training, and then in the Durham Police Academy, and then as a field officer. So in those records, if he failed to call in, he didn't claim in this trial, but in the motion to suppress hearing, you may recall, officer testified, well, this is the only time in 7 years I ever didn't call something in. Okay, well, you didn't say that during trial, is my recollection. But if he's trained year after year to do something, and the testimony, well, I just didn't do it, the fact that he's been trained repeatedly to do something, I think it makes a difference. But let's look at the chase issue.
Well, no, I'll stay with this thing.
All right.
So you asked him a question. You were supposed to call us in. When you make a stop, you're supposed to call it in. Is that not correct? We're going to stay with the call in first, then we got the report, then we got the chase. But And you're supposed to do that. That's standing order with the Durham Police Department. Is that correct? That is correct. And you didn't do that, did you? I did not. Putting on other evidence that he had been taught a lot and still did not, is that not extrinsic, trying to put extrinsic proof in that he really didn't do it? I mean, when he said, I didn't do it, and it's a violation of the Durham Police Department rule. So I'm trying to get hone in on what you're saying, that the power of that impeachment is more if you've been taught that multiple times versus I didn't do it. I think he said he knew it and didn't do it.
Yes, Your Honor. In a better cross, and my esteemed partner John Donovan would say, well, Mr. Charnes, why didn't you start off with, in BLET, here's what you were taught. And if you have the document, you start off slowly. It may take a day to cross-examine him about how he's been trained. And then the final question on day 2 or day 3 is, you didn't call in. You didn't call in Durham Emergency Communications after you asked them the 1,000 questions to get to that point. So Your Honor's right, if you start at the end and you say you didn't call in communications and it's a violation of general orders, that kind of ruins the cross-examination. The Sixth Amendment is this powerful device to get at the truth. And the way you get at the truth, sometimes you pull teeth, sometimes you slowly are fishing. And in this case, starting off with BLET, very slowly going through, you did this, you took an exam on this, and you actually passed it. Congratulations. And then by day 2, when you get to the final question, you didn't call it in. That's a cross-examination. That's something worthy of Gideon versus Wainwright in the Sixth Amendment through the 14th Amendment. That's doing your job. So yes, it's very different to do that slow cross-examination. You go through bit by bit, and then when you get to the end and he says he didn't do it, well, that means something on day 2. The 2-question cross-examination is kind of weak. That's kind of taking shortcuts. The Sixth Amendment says, go for it. And how can you call it forechecking? We're playing in their end. That's what cross-examination is not playing in front of your own goal. It's a contact sport. So I think it does make a difference. And if it didn't make a difference, why am I still talking about this? Am I just, a glutton for punishment? I'm not. We're talking about this because this is important to me, to Your Honor, and you're asking these questions. These are incredibly important questions because to do a good cross-examination, it might take some time. And in this case, I wasn't in a position to do that. Same thing, the whole question about the workers' comp records. I didn't ask Your Honor to put officer back on. What I did in closing is just said they didn't disclose this. What's the answer? Because if I put him back up, it just didn't seem it would work well. But if I had all this stuff, that's a different matter. Then you slowly go through this and you get to the end. So it's the art of cross-examination, the science of cross-examination, what the Sixth Amendment requires of me as a zealous lawyer. And if I'm not a zealot, I'm not doing my job. With a capital Z, with a real cross-examination where the witness feels that power of the cross-examination. So same thing with the chase. In this case, I don't have all these records going back for 8 years where this officer's taught, you don't jump onto a moving car. That's basically what he claimed he did. So we made the demonstration. Here's the car in the chair and it's moving away. Why would you jump on there? I mean, common sense would tell you not to do it, but if I have hundreds of pages of records and I take them through a day of, you don't do that. You had his ID. You had the registration. You know what he looked like. Why possibly would you do that? And you take him through his training, 7 years of training, to not do that, and then you said, well, the general order says you don't do that. And his answer was, I believe he was denying that was even the case. You can't chase, but he said that wasn't a chase. I think that was the theory. But if I go through all his training, they're going to have scenarios in these trainings. I've received some of this materials in civil cases, Your Honor. They're voluminous, they're gigantic, and I want them all. So whether I go through them with the eye of an advocate or the prosecutor looks at it with the constitutional responsibility, it's either impeachment, Sixth Amendment right to cross-examine, or it's the constitutional responsibility of the district attorney to do this. So with this subpoena, I'm trying to get this material because it's important. Rules were important to this case, incredibly important. We spent a lot of time talking about those rules. The defense did in closing and in our cross-examinations. If you recall, Your Honor, different witnesses got up there and asked various people, would you leave a car on? Why not? Well, someone would drive away. I mean, it seems common sense, but what kind of training did they get about turning the car off? It's common sense, but how many rules in general orders of the police department, the Durham Police Department, are there in various places that I can't even imagine that talk about turning that car off? It's dangerous. Because Officer Stewart's testimony, it was discretionary. If I'm recalling correctly, it's discretionary if you think someone's grabbing down. So my cross-examination of him would be very much different if I have all those records. So same thing with use of force. They're trained to do certain things. You're not trained to, I'm scared, and the officer, I'm fear deadly force. It doesn't work that way. Their training is very detailed. In the case in Charlotte, where the ex-football player was killed by one of the officers, they went through all the training. In that case, they had training officers. They had testimony about the training officers. I bet in that case, I don't know for sure, but I bet they got all this material. I'm doing the best I can as a court-appointed lawyer with my pen, and my partner who can be here today because he's not in another courtroom, and I have no staff. So I'm doing the best I can running around serving subpoenas on people. I don't have all these people or all these officers out in the audience that can do my bidding and help me. It's just me. And I'm doing the best I can. I'm fighting as hard as I can for my client, doing what I think the Sixth Amendment requires. So I think this is an important issue where I wouldn't keep messing with these subpoenas, because I want an appellate court to see what it is I didn't have access to. So if he's convicted, and hopefully that's not going to happen, there's a record so that appellate lawyer, which can't be me because they said I'm incompetent and ineffective and asked to have me removed at the beginning of this case, I can't be that appellate lawyer now. That's an issue. So it's going to be someone else. But I want to do my job to preserve the record so something's sealed up, so that lawyer in the appellate defender's office says, Charnes, he did his job. He did his best. Whatever, this case is on appeal, if it gets on appeal. So that's basically how I would answer Your Honor's question. Maybe it doesn't satisfy you, but that's what I'm thinking as the trial lawyer now, what I would want if I was an appellate lawyer. At this point, when the jury's deliberating, what was it that I didn't have? And that's where I think I could have been more effective as a trial lawyer in cross-examination if I had this, and that's why I was trying to get it.
Thank you. Mr. Smith, you wish for her.
Your Honor, as the city's already stated, we contend that these records are personnel records. there is a clear preference by the legislature that these records be kept confidential and only be released by order of the court if there's a compelling reason to do so. It sounds honestly to me like basically a fishing expedition to go through this officer's employee records. Brady requires more than you just articulating that the records are somehow related to this incident, that there's some remote connection between them and this particular incident. You have to be able to establish that in order to be Brady material, it has to be favorable and material to the defense, which means it would likely impact whether the person is found guilty or not, or reduce their punishment. I have not heard anything that would indicate that. As the city, we are well aware of our obligations under Kyles versus Whitley, which requires us to turn over material that is potentially Brady material to the state so that they can make a determination and then do any disclosures that they feel are appropriate under Brady to the defense. But we also have an obligation under state statute to protect these personnel records, and we can only turn them over when we reasonably believe that they contain Brady material of the subject of an order. So that is why the workers' comp record was not turned over, because we had no reason to reasonably believe that it contained any Brady material. For us to turn over records to even the state when there is not that connection there or a reasonable argument that there is that connection, we could be committing our own criminal offense. So if we had an IA record, and Mr. Tron should know this, we had a case that he was trying with the Attorney General's office, and when an issue came up about there being an IA record that the person did not follow proper procedures and that could impact the case, we didn't even argue, we turned it over. But we're not going to just wholesale turn over every personnel record that in any way relates to an employee on the theory that somebody might be able to make some connection that is in some way useful to them in a case. Again, I haven't heard anything that would demonstrate that any of this material would constitute Brady material. There doesn't seem to be a dispute about whether he followed the training or not. I don't see how providing the training material would change that at all. As far as the Sixth Amendment and his ability to effectively cross-examine him, again, weighing that against the personnel interests of the employees, I don't see how that is very compelling, because again, there seems to be no dispute that he's being asked, did you get this training? Did you not follow this training? He's admitting that he didn't. So that is our argument. We would ask that the court not release these files of Officer Stewart.
Can I make a one-sentence response about
one sentence would be good.
September trial with the AG? I'm representing a former Durham officer, and it's going to trial. In that case, the internal affairs records, I made a motion for them. I believed, I knew what was in there. Judge Height reviewed those records and turned them over to the defense. So it was an in-camera review. That would be mine.
Well, thank you. Well, here's my decision on this. As to the subpoena, to the extent that the first request was all warning tickets issued by Officer Kelly Stewart from the inclusive dates there, the court finds that the representation made in court that there is no such record maintained as to warning tickets, at least not an institutional record by the Durham Police Department. And an affidavit that was handed up, I marked it myself as filed at 3:30 p.m. today's day, put my initials on it. I know we have this issue about the clerk not having a file there, file stamp. As to the second request, I've got multiple layers of issues with this one. That, you know, in closing statements of the attorneys, they picked words. Well, here are my 3 words: fox, hen house, fishing. From a defense point of view, and this is always going to be an obligation to release Brady material that might, or material that might not otherwise be found. The initial review of that oftentimes is by the person with the obligation, with what the defense would think is no, or contends is no sort of accountability that requires that person to be completely forthcoming. So from a defense point of view, it's the fox guarding the chicken house. On the other side are folks that keep records, and the requests are made, and they are voluminous from time to time. I don't know about this particular one you indicated. I don't have any reason to doubt it, thousands of pages or something of that nature, but and it's viewed as fishing. In other words, I want you all to provide all of this stuff to me, and then I'll sort it out, you know, as a defense attorney, to see whether there's anything I want to use or not use or whatever. Just you provide all of it to me. That's how it's viewed from the other side. Those are sort of the 2 parts of it. Now, I've mentioned this before, but I've been a prosecutor, and I've been a defense attorney. And I've been a defense attorney, I was a defense attorney a lot longer than I was a prosecutor. But I handled a whole bunch of cases prosecuting as well in a short period of time. That's just kind of the nature of the 2 types of practice. So I really don't have an axe to grind, or whatever the pattern jury instruction says about, you know, I don't favor one side over the other in this argument. So here's how I see it. I find that the second request is overly broad. It does not. There were areas of focus on some matters in which Mr. Stewart, the cross-examination was, I believe that Mr. Stewart did not call in the stop. He had a distinction as to the chase, but did not deny that there's a policy against engaging in a chase on a routine traffic stop. He had recognized the requirement of the SDI 122 form, but had a reason that he espoused for not doing that. And the escalation of force. There was escalation of force testimony on, I believe, on direct examination, and there was ability to cross-examine. I don't remember the specifics right, just as I'm talking right here about the extent of the cross-examination on the escalation of force, because it was somewhat integrated throughout that. That's one thing, is I find it overly broad. The other thing, I think the timing is of presenting that is problematic for me. I recognize we had I call it dancing with the dancing bear. I don't know why I call it that, but you're just kind of hanging on for dear life. It looked like that Mr. Charnes was following what he understood the protocol and procedure to be. Ms. Smith has explained it, and that's reasonable as well to somebody who knows neither side of this question. And on a purely legal analysis, Ms. Smith's position is the one that I find as the legal basis. Now, there may be a customary basis of how things are done, but the legal basis would be that instead of the sheriff's department serving it, an officer with the Durham Police Department will take care of serving or trying to serve the subpoenas that go to the DPD. Sort of relieving, kind of an agreement to relieve the sheriff's department of that responsibility. And it's not giving it to the initial individual, but the individual either telephoning if it's just a subpoena to appear, or physically giving it to the officer if there are documents to be produced. That's the crucial part of it. Anyway, we got no need to redocument what we talked about earlier about it getting to the sheriff's department, but after 10 o'clock and all that goes with that. I don't have much hair left, so I didn't have any to pull out. But on a purely legal basis, again, that's I found it's not unreasonable for the sheriff to not serve that original one. So Mr. Charnes served the one on Mr. Smith, Officer Smith. What's his position?
Deputy Chief.
Deputy Chief Smith. That part's not an argument. The timing is an argument. I had issues with the timing. I had issues with the broad nature of it. There is sort of a showing. I have no problem with the fact that you might want this information for impeachment purposes. I have no problem with that concept. There is some showing, even though the state really is the one that always has to carry the big burden there of proving generally, there is a requirement of some showing for something that you're seeking in connection with Brady material and not a fishing expedition trip. But anyway, so I've got that concern. I can see how individual training matters that are in individual files, in individuals' file, would fall under the person, being part of a personnel file, as compared to the materials that were used to teach this officer and all officers or something. They're two different things. Training materials could include something that's in a personnel file. It could include like that, those orders, those standing orders and things like that. I can't tell from the subpoena a distinction between what's being requested, and maybe all of those being requested. But some of them strike me as potentially, as they relate to the officer's personnel file matters, his training, his grades, his review from instructors, things in the personnel matter that they're going to have to kind of run by a judge in chambers, in camera to make sure that it's something that's really relevant, pertinent, and at all. And then besides the Brady aspect, whether it's helpful on impeachment or any other way of promoting the defendant's cause. For that reason, I am sustaining the objection to the subpoenas. The question comes as to whether I require that file to be put under seal, and I'm going to require that an appellate court tell me that, because I am not going to do it here. If the Court of Appeals does say do that, and the request has been made to do it, it's clear on the record, it's clear that I denied the request, I tried to put out as many reasons so a Court of Appeals could see what it is, and that fact alone may be some
issue on behalf of Mr. Riley. Positive issue. If all of this is assuming that the jury's not to do anything other than acquit him. And if it quits, I don't believe we have anything left on to appeal if there's an acquittal. On the other hand, if it's not an acquittal, wants to make sure it's preserved. I have complete sensitivity to that. But I'm putting on record, I'm not putting that under that for those reasons, the overbroad nature, some of the vague nature, some of it involving personnel matters, as declining what that subpoena was asking for, and that will give Mr. Riley, if it ever becomes reality, to clearly present to whatever appellate lawyer handles that what I meant and what I said. I hope there's nothing vague about that. The objection is sustained.
Another objection, exception.
And that is noted. I would like, this has been served, which is what was necessary, and we all wanted to have this conversation, that Ms. Smith, I'm going to return this objection to you to get stamped, and I ask that you send a stamped copy to Mr. Charms.
Okay.
And you can do it to the DA if the DA wishes it, and the original of course goes with the court file. It's 4:15. So it's too close to 5 o'clock for them to have a recess. We'll be at ease.
Thank you.
Thank you, Your Honor.
I'm still on the record. Ms. Smith and Mr. Charles, good arguments.
Thank you.
Thank you both.
Thank you, Your Honor. But not good enough for me.
You've won your share.
Yeah, okay.
How did you think? But fortunately, I got 5 minutes.
Yeah, that's what I was.